the leaded one, Vingai Madzima, who will be sharing on the legal, regulatory, and policy frameworks for sustainable infrastructure development. Seeing that he's also an investment lawyer, I think I would also challenge him to talk about, or expect him to deal with the issues of financing issues. But I don't today, since we have professors, I don't know whether they're calling the learned one. I don't know.
No. I don't think I'm the learned one here. I don't know if you can get my presentation ready. Yes. Okay. They say that you're a product of your training. And as a lawyer, I was trained to be proactive. So I'm not a reactive lawyer. Even in the firm, I try to deal with matters before they occur, a preventative approach. So and that is the idea that I brought when I was preparing for this particular presentation. And to prove to you what I say is true, firstly, I would like to thank the previous panel for cancer. Although they scared us, I don't think I was able to do the presentation if we didn't have to go to lunch first. The statistics, as we were told, is that 2 or 3 of these gentlemen probably will get cancer. And so what I then did, because I'm a proactive lawyer, I had traditional food at lunch, in moderation. And then I also did my 5-year plan, which is going to be premised on a preventative option. I'm going to reduce my alcohol intake in the next 5 years. And the last one that I'm implementing immediately, is it possible to get this one? To get a microphone. The last one that I'm implementing immediately is that I will not be driving my wife anyway. And that was the advice from Dr. Matsika. That being said, we had Engineer Gurupira yesterday when he was discussing on sustainable infrastructure. He basically highlighted one point. He said that for Africa, it's a difficult conversation because we only contribute about 3%. And a part of me is inclined to agree with him. That being said, I've then structured my presentation so that we talk about unlocking finance, because in a room full of CEOs, it doesn't matter whose money it is or what you believe. If the money is available, we'll talk about the legal and things that we would need to achieve first so we can unlock green money or green finance. So that's what I'm going to talk about. My thinking on sustainable infrastructure development or sustainable, I know his ideas were premised on energy, do not really matter. It's a conversation about unlocking finance. That is what I was then instructed by Dr. Juru to deal with. So I will start with the general considerations in infrastructure. I don't think this is working. Okay, I'll start with the general legal expectations for smart infrastructure investments. This is what lawyers normally look at in a general infrastructure project. Whether the investor is protected, whether the rights are enforceable, the local community and the environment, which is going to be our main focus today, is protected, if there are predictable timelines, and the process is transparent. Obviously, I will not comment on a lot of things. So, like I said, what I'm going to deal with mainly is then unlocking the legal considerations in unlocking infrastructure investment. My apologies if once in a while I give you my back. I'm not intending to, but it's because I'm using this particular screen, so I move with you. Yeah. Oh, I can see this one. Yeah. Ah, okay, thank you very much. I'll start with the due diligence process. International and regional or continental green finance, or finance in general, in their due diligence processes, they are now including the ESG component to unlock finance. And here we are talking about either green finance or get concessionary finance. I remember yesterday, Engineer Gurupira spoke about the ferrochrome industry and say that they're giving a rate of 7.9 cents per kilowatt. And it was of interest to me because in about 2016 or 2017, I was the lead lawyer in negotiating for the ferrochrome company that has since closed with ZESA on this particular tariff. And our main base in our negotiations was the social impact of the tariff that ZESA was proposing. I think at that time, ZESA was proposing between 8 to 9 cents per kilowatt hour. And we managed to achieve 6 cents per kilowatt hour. We were probably still the highest charges for all ferrochrome producers. But I hear obviously ZESA has moved on. They've encouraged the ferrochrome producers to basically have solar farms. So it's a consideration. But we got a concessionary rate based on the S part of the ESGs. It was the social impact for the community in Kwekwe. At the time, most of the ferrochrome plants had actually closed, and we used that as our negotiating tool with the Ministry of Electricity at that time, and ZESA in particular. So ESGs are useful, especially when negotiating with public institutions and government, because of the social element in them. And so that's useful. I just thought it's something that I should mention. It was of interest. And then in sustainability frameworks, you can unlock finance in regional, continental, or global institutions, just using the sustainability frameworks. Obviously, the negotiations would include other aspects, but these institutions are mandated by law now to consider whether the project takes into cognizance ESGs, or ESs more than anything else. If you're doing PPPs in Zimbabwe, you get favorable selection. It's actually in our statute that they should consider what the social and environmental impact of the project when you're doing it. Then we talk about, obviously, the green money, their sustainability funds, the Green Climate Fund, the Africa Development Bank has to consider social and environmental protections, and then we have the Sustainable Energy Fund for Africa. Those are some of the funds available in dealing with ESG matters. International financial institutions deal with Equator Principles and International Financial Cooperation Performance Standards. So I'll talk about Equator Principles in general, and I'll give a practical case. We had a case, it was also in the mining sector, where as part of our strategy, we wanted to stop certain funding as commercial lawyers. It was not personal to a certain institution or company, so that there were other processes that needed to happen. And what we did was we wrote to the financial institutions in England and South Africa that those particular companies, they are violating Equator Principles, and the bank is bound by those principles not to sponsor. So it's international law. The banks subscribe to the Equator Principles, which says companies have to be compliant in terms of their environment and social issues before money can be lent to them. So it's a serious issue. It's an issue that lawyers can use, even if some institutions do not want to subscribe. You can have your funding stopped by your competitors. It's unruly, it's probably unfair, but it's somebody gets paid. Obviously, I spoke about PPP agreement, and then I'll speak about other capital finance sources, China, for instance. So in terms of ESGs, or environmental and social issues, they are governed either by hard laws, that's your acts of parliament, the constitutions or regulations, or the soft laws, which is your policy and your guidelines. China takes a soft law approach to social issues, because obviously you can then say, I'll just look east where the money does not come with those particular conditions. So there are the guidelines of 2021, the Green Development Guidelines for overseas investment. They also subscribe to sustainable infrastructure development. We have the Ecological and Environmental Protection of Foreign Investment Projects guidelines, which are given to Chinese companies to get into projects where they also subscribe to sustainable infrastructure development. If you look at the Road and Belt Initiative, China actually sat down with a company in London, and they came up with a sustainable, they prescribed minimum or benchmarks for sustainable infrastructure development on that particular issue. So the whole world is moving in that direction. We cannot then say we'll just ignore it just for just. I'll talk about our legal position in Zimbabwe. Well, in Zimbabwe, first of all, I would want to say, when it comes to environmental laws, protection, and or protection for environmental and social impact, we have a mature law. It is comparative to most of the laws on the continent. Our only issue is our laws are fragmented. They are found in different areas. That is our issue. Not that the laws are not adequate. You find the laws on one side, they complement the equator issues. You find the laws on the other side, they even complement the continental guidelines. But they are found in different places, and it's difficult for an investor, more than anything else, to then be able to identify where. Of course, we have ZIDA that assists, but we still have the problem that these laws are everything, they are everywhere. That being said, issues of environment are found in our Constitution. Section 73 speaks about the right to an environment that is not harmful to health and well-being. And then Section 13.3 talks about infrastructure, the state's obligation to provide infrastructure. So these are justiciable rights, meaning you can take these rights to court. It's guaranteed by our Constitution that you must have sustainable infrastructure development. Our statutory position is found in the Environmental Management Act, which creates EMA, which then regulates that particular law, dealing with issues of EIAs, etc., before infrastructural projects can commence, or projects that potentially can be harmful to the environment. We have ZIDA, where it's fourth schedule, it gives provisions for environmental compliance and dispute resolution mechanisms. I saw Prazia earlier on, when if you're disposing assets, obviously, or getting into projects that are state projects, you have to be compliant in your bid valuation with sustainable issues. We also have other laws that I did not mention because obviously they are fragmented. You got your Water Act, dealing with sustainability issues, your Electricity Act, and other energy acts dealing with sustainability issues. These things are everywhere. And obviously, in the interim, from a purely selfish point of view, I'm not advocating for the change because they keep us at work. From a policy perspective, NDS2 is which will start obviously from 2026 to 2030, is almost synergized with the SDGs and is very strong on sustainable development. We have the National Climate Policy of 2016, which obviously is introducing, it should be the National Climate Management Act. It's still a bill at the moment. And eventually of 2025, it's the bill we eventually, I am assuming, going to hold all the laws in one place for our sustainable energy, sustainable infrastructure development and everything else. I'll talk on cross-border infrastructure investment, continental and global considerations, because our theme is on Africa and not just on Zimbabwe. The African Union Agenda 2063 embedded sustainability in infrastructure law and policy. We have PIDA, the Program for Infrastructure Development in Africa. It harmonizes standards for environmental compliance as part of financial considerations. We have the African Continental Free Trade Area. Article 3 is promotion of socio-economic development and was ratified in Zimbabwe in 2020. It also speaks on sustainability issues. On the international front, we have the Paris Agreement, which we are a signatory to, although America has come out of it. And from an observance point of view, the opposition so far, from a sustainable infrastructure perspective from America, has been confined to issues to do with energy. It hasn't transcended into other areas as we speak. Paris Agreement has makes financial flows consistent with climate resilient development. And then I'll do a comparative approach. I've selected 5 countries, ultimately, that are big on, at the moment, on sustainable infrastructure development. And as we speak, Rwanda and Kenya have unified or a one reference point that deals with climate issues. And at the moment, why it matters, they are the 2 countries right now that are bidding to have some of the UN agencies that are relocating from Switzerland move to their locations, and they are using these codified documents as the carrot to say you can see that we are compliant with international law and our compliance is in one place. South Africa is big on sustainability. Somebody spoke about pension funds being other useful areas for sponsorship. Most of the sustainable infrastructure development in South Africa is sponsored by pension funds, as opposed to outside money. And then Nigeria suffers more or less what we suffer from, where the law is developed but weak implementation models. Here, obviously, our EMA is under-resourced for what it should be doing, and we should have more allocation in terms of resources to be able to fully implement its obligations. Because from a policy and a law perspective, it is adequately, in my view, equipped. So I put down a few takeaways for CEOs, understanding that your job really is to think in 5, 10 years, as we were told, and be able to proactively plan. I think the first takeaway is that access to concessional finance, for whatever reason, despite your personal views on the subject, has to do with having sustainable projects. And the second one is to future-proof projects or investment by incorporating NDS 2, that is starting from January next year, having a look at the Climate Change Management Bill of 2025 that was put up, and seeing that the project is indeed compliant. And if you can also integrate continental international standards to widen the pool of finance, and also have access to green finance, and then ensure that as you do your DD for your project, besides its feasibility and profitability, you also look at ESG issues. Thank you very much, and have a good day.